Parole evidence is evidence that's external to a contract. It's typically offered to vary or explain the terms of a written agreement. Is parole evidence admissible to prove that the parties orally agreed to a condition that isn't reflected in their written agreement? We explore that question in Hicks v. Bush. Frederick Hicks entered into a written agreement with members of the Clinton G. Bush Company. The purpose of the agreement was to merge the parties' corporate interests into a new holding company, known as Bush-Hicks Enterprises. Hicks would subscribe for 425,000 shares of the new company's stock. The members of the Bush Company would subscribe for more than 1 million shares. In consideration of the subscriptions, the parties agreed to transfer the stock they owned in the operating companies to Bush-Hicks. The subscriptions must be made within 5 days of the agreement's date. If Bush-Hicks didn't accept any subscription within 25 days of the agreement's date, the agreement expressly provided that the parties' obligations would terminate. The parties subscribed in a timely manner, and those subscriptions were accepted. Hicks transferred the stock in his corporations to Bush-Hicks. The members of the Bush Company, however, didn't transfer their stock. Accordingly, the merger never occurred. Hicks filed suit and sought specific performance of the parties' agreement. The defendants argued that the parties had orally agreed that their written agreement wouldn't take effect unless they could raise additional equity. This oral condition precedent wasn't satisfied because the funds were never raised. Accordingly, the defendants argued that the written agreement never became effective. The trial court allowed the defendants to introduce evidence of the oral agreement over Hicks's objection. The court then entered judgment in the defendants' favor. The New York Appellate Division affirmed. Hicks then appealed to the New York Court of Appeals.